Mr. Hillegas, you're standing up like you want to address the court.
I'd like to object to everything that you just said.
All rise. Second Judicial District Court, the state of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you. Please be seated. May have jumped the gun a minute or two, Mr. Stege. My apologies.
Thank you. I'm sorry.
Okay, good morning, everyone. We are on the record in the case of State of Nevada versus Mr. Hillegas and Mr. Handte. Case number is CR 19-1535A and B. The court recognizes Mr. Stege, prosecutor, on behalf of the State of Nevada. Mr. Prasad, standby counsel for Mr. Hillegas. Good morning to you both. Mr. Handte, his counsel, Mr. Silverberg.
Good morning, Your Honor. Good morning, Your Honor, and I'd like the opportunity to address the court as I did last time, if quarter two.
Possibly. Please have a seat.
Thank
I'll
you.
put it on the agenda.
I would also like to address the court.
Thank you, Mr. Hillegas. That's, again, that may happen. I have to see how we're doing today.
I think we have the whole board to satisfy each other.
You know, Mr. Handte, we're going to talk a little bit about comments you made in front of the Board of County Commission and how that relates to your pretrial supervision, but you don't want to put the court in a more concerned mood than it already is, so let's just wait until I call on you and then I'll decide whether you'll be heard. That's how we're going to approach this today. Now, first order of business, I want to talk about Mr. Hillegas' competency evaluation. We have the one which really was a non-evaluation with the default position from a month ago that because no active engagement occurred, the evaluator decided to their reading of the statute that it would be a finding of competence. We did not have the second evaluation a month ago. I don't see that one was filed, of course, so Mr. Prasad, what's the update, please?
So, Your Honor, as I touched upon last time, the issue here is we have a contract, the county has a contract with NAFCARE.
Yes.
So we're forced to go through that contract, get the evaluation done. Mr. Hillegas is one of many cases where it's still pending an evaluation at this time. I have reached out a few times, my office has, specifically on Mr. Hillegas' case to try and see when the next evaluation is. Based on the responses I've gotten, none have been scheduled yet. My suggestion to this court,
Hold on, let's just stop there. None have been scheduled yet?
the second evaluation has not been
Or is
scheduled.
there something this court can do to move it forward?
So my suggestion to this court is its last order on this indicated a strong preference for an in-person evaluation, which we included in our evaluation referral. I would suggest that we update that to a mandatory in-person evaluation because the most recent response we received from NAFCARE is they're attempting to set up their telehealth equipment, which is causing part of what causing the delay, as I understand it. So I think if this court would amend its order to require it in person, we can update our referral to that. I don't want to sit here and guarantee that'll make it go faster, but I think that will help speed the process up.
They have an office here.
I am unaware of where their office here is.
Mr. Stege, I'll hear from you in a minute. Would you please sit down? I'm aware that there's a side of the state would like to explain. In person, as in if he's in the jail, they go up there. If he's out of custody, which I want to talk about his custody status this morning, he goes to them.
That's correct, Your Honor.
Because right now the order is gray and it allows for a possible virtual consultation, and so they're not in giddy up mode to get him in person because the order doesn't so direct.
So that's my understanding. The most recent order was a strong preference. We put that in our evaluation referral that the court has a strong preference. These evaluations.
Well, let me tell you why I had it. I'm just reflecting back. One of the reasons that I directed it in that fashion was I didn't want the in-person piece to delay things. So if the best we were going to do to get an efficient, comprehensive, accurate, timely evaluation involved virtual contact, the court would hold its nose and allow that. I didn't realize for a moment that the faster way possibly would be to order in person. Sounds like that might be.
It might be the faster way, Your Honor, because again, the most recent update we received from NASCAR and reached out specifically on Mr. Hillegas' case, which I believe was about 2 weeks ago. We did reach out last week with no response as of yet. But the response we received 2 weeks ago was that they're working on setting up their telehealth equipment.
As in, we're working on that direction.
That's my guess.
Let me, before I hear from Mr. Stege, let me move to Part B here. And Part B is, I don't want Mr. Hillegas lingering in the Washoe County Jail. We know he fled. We know he was brought back. We know we have concerns that he won't engage and follow court orders. That's why he's been in jail all this time. But he's lingering. He appears to be deteriorating. At least his physical presence appears to be not as strong and vigorous as it's been in the past hearings. I would consider strongly an option where if the defense presented in writing within the next day or two, I would get you all back in here Thursday morning of this week to discuss circumstances where Mr. Hillegas could be let out of the Washoe County Jail to house arrest with some type of anklet tracking to make sure we know his whereabouts. And then he'd have to stay at home and wait for this. As long as I knew, and pretrial services knew where he was going to live and if with someone else, with who. As long as he understood he would only be allowed to leave the home to go to church if that's his thing, medical care, meet with his attorney, food, things like that. He can't just socialize and go out and about. And that way he's out of the jail and he's back in a more comfortable place, so he can hopefully regain some of the strength that he appears he may have lost while he's up at the jail. I would consider that. Of course, we would need a hearing. I would need something in writing on what the defense would propose, pending the in-person evaluation. Because I'm not for keeping Mr. Hillegas in jail while we go through these competency proceedings. We all are aware of the well-known axiom that punishment follows conviction if any does not precede it. And from where I'm sitting, Mr. Hillegas has been in jail a long time awaiting the evaluations. Granted, he's the one who left the state, he's the one that caused delay, and so there's a mode of thinking that this is a product of his own doing. Nevertheless, I don't want him lingering in the jail. And if you said, Judge, he's going to be evaluated next week, they're coming up to the jail to see him, we don't have a meeting this Thursday morning, but we don't have that. We have a menu order, make it clear it's in person. That might move it up a little bit, but even that's a bit uncertain. Do I have that right?
That's correct, Your Honor.
Okay. Mr. Hillegas, you're standing up like you want to address the court.
I'd like to object to everything that you just said, because your
Mr.
order,
Hillegas,
your order was null and void because I
Mr.
challenged your
Hillegas,
jurisdiction.
that's enough,
And
sir.
you've lost jurisdiction. I did
Mr.
not flee
Hillegas,
the
I'm only going to
state.
ask you this one more
I
time. then we have the
filed
deputy.
3 motions, writs,
I'm aware.
challenging your jurisdiction.
I'm aware of that, Mr. Hillegas, but right now I need you to sit tight and let me do my thing here. Mr. Stege, on the issue of how we, the one approach that the court is being asked is to amend its order to direct in person. Second thing is you've heard the court's concerns about Mr. Hillegas staying in custody while this process plays out. What are your thoughts on either of those or things related?
Okay, they have a contract with an organization to do evaluations. The court ought not to jump into that fray.
Well, hold on.
As well.
By ordering it in person, am I jumping into that fray?
Well, if they have a contract that says that it's permissible to do telehealth evals.
Unless otherwise ordered by the court. They wouldn't sign that contract if the court thought that it would benefit from an in-person evaluation.
Well, in any event, the court should not forget that this is on the heels of not one, but 2 separate evals where Roger Hillygus has failed to cooperate, right? The first one was telehealth, and he went on with this sovereign citizen nonsense with him and prevented it from
Excuse me
happening.
one second. Mr. Hillegas, please have a seat,
I
sir.
would object that I did not.
Mr. Hillegas,
It's on the record that I've objected to not refusing to cooperate.
And Judge, if he does that again, I'm gonna ask you to take action. This whole proceeding has been marked by the defendant, Mr. Hillegas, as well as Mr. Handte,
I object to that too.
Martin acting as, see?
So gentlemen, It's tough to sit in court and listen to people speaking about you, your behavior, your actions, your beliefs. I get it. And oftentimes, in this type of an adversarial process, feelings are hurt. People take offense at the way somebody else looks at the system, the process, what their actions constitute. But you can't just jump up and speak whenever you want to. It doesn't work that way.
When there's
If you-
falsehoods being said, I object to perjury and falsehoods being made against me. I object to those.
I need you to be quiet, please. If you continue to do this, I'm gonna have the deputies remove you, bring you downstairs to the law library where we can turn on maybe a feed so you can watch the proceedings here. But I'm not gonna let you stay in the courtroom. I need you to be respectful of the process, even if you don't like it, and even if you don't like what you're hearing. Believe it or not, at this point, we're trying to get our feet under us of whether you can represent yourself. And if you can, then I will allow you to be heard, to make objections to things that you have a basis to object to. But we're not there yet, all right? So please have a seat. Right now, I want to find a way to get you out of the jail. If there's a way to do it that protects the community and make sure you're going to get evaluated. All right, go ahead.
So he's been uncooperative with 2 evaluations. He ought not to benefit from that. This hearing, I'm prepared to, I want to do 2 things with this hearing. Number 1, I wish to challenge the present situation where the defendant is even in competency proceedings. I don't think there's cause to believe that Roger Hillygus is presently incompetent. I would do that by way of testimony from Dr. Loring as to her evaluation and interaction with Mr. Hillygus. The idea that the court is desirous of letting Mr. Hillygus out, I think that is a mistake. Looking through the factors to be considered in our bail factors, flight, it's concerned with flight. We have 2 instances of flight. We can get there. I know we can get there. I'm happy to argue that, but for today's purposes, this continued and deliberate sort of obfuscation and delay as to Mr. Hillygus and the competency evals. My ask today is either we find him competent based on the 1 eval and his waiver as to the other one by refusing to meet with the first evaluator, or to dispense with competency proceedings because this court's belief or suspension of proceedings way back in 21, I think there's been material changes now and evidence we can rely on today to find that there is not doubt as to his competency. I would add, of course, that this is on the heels of the very first evaluators, 2 evaluators that this court set up in person, out of custody, that Roger Hillygus has deliberately failed to appear and went on the run and was arrested in Missouri so many months later.
Brief response to what you said.
Okay.
Don't like either option. If we had both evaluations filed, we set it for a hearing for the state to traverse or emphasize or say there's been a change of circumstances, sure. But we're 1 evaluation short. Now, I understand the state, don't need it, because the concept of competency is fluid. 1 may be competent to proceed to adjudication for moments in time, weeks in time, months in time, years in time, and be incompetent to proceed on either side. And it sounds like the state's position is, Judge, as of today, good to go. But let me tell you what the court's concern was way back when. Remember, competency, legal competency, under the statute, I believe 178-400, 3 prongs. Do they possess the ability to comprehend the nature of the criminal process against them? 2, do they understand the nature and purpose of court proceedings? And 3, and this is really the linchpin, at least from where the court's concern was at the time, and continues to be, can they aid and assist with a reasonable degree of rational understanding in their defense, either with an attorney if they have one appointed, or if they've exercised their right under Ferretta to represent themselves, to assist themselves. And so it's really the reasonable degree of rational understanding. Really nothing has changed from the court. If anything, it's gotten a bit more concerning to the court that Mr. Hillegas in particular is struggling with that based on his beliefs, his views, his expressions, his body language, his demeanor, his approach. And so if we're going to have a hearing where you put somebody on the stand who says, you know, somebody can have certain beliefs and act on those beliefs, that's not an equal sign to legal incompetence. That's an equal sign to somebody who's antisocial or has disparate views or views that are a minority view, but nevertheless it's theirs, but that's not the same. But I don't think the court wasn't prepared to have that hearing this morning because I've one evaluation and even that one is a fail to engage. So that's where I'm leaving. I'll hear from you again in just a minute. Mr. Hillegas, I do need you to have a seat, sir. I realize you have things you want to say. You can whisper to
Can I
your
make an
attorney.
objection?
You cannot
To
make
my
an
beliefs
objection.
or my rights?
Well, you can write these things down and slip it to Mr. Prasad and if he
Mr.
wants to.
Prasad has been terminated, he's been discharged, he's been withdrawn.
All right, well, I understand that was your effort or belief or hope, but at this point, he's still your counsel to the extent the court has appointed him a standby for these competency proceedings. And I just want to emphasize, if we get through these competency proceedings, and if Mr. Hillegas is deemed to be legally competent, then I said it at the last hearing a month ago, likely either discharge Mr. Prasad completely or his role changes. But first things first. Mr. Prasad, based on the court's discussion with Mr. Stege or anything he said, what say you?
I think that the court kind of touched on what I want to touch on, which is once competency proceedings have been initiated, and they were initiated by this court, is my understanding, I think the statute really requires those two evaluations to be conducted before we can move forward within the proceedings. So I understand everyone's frustration at the length of time this is taking, but I think by statute, we really need to get that second eval.
Well, let's jump down the road then, because we talked at our last hearing about what the immediate future looks like after we have the evaluations. Let's suppose custody status changes or doesn't. Let's suppose he's evaluated in the near future, and let's suppose it looks a lot like the first one. Then I'm going to have an evidentiary hearing. The state's allowed to subpoena the evaluators, as is the defense, and I'll hear from them. And I'll make a determination whether Mr. Hillegas is legally competent to move forward in this case. And as I said before, if the court's determination results in a positive that he is, your role will likely be completely eliminated or changed to something peripheral, rather than a direct involvement in these competency proceedings. On the other hand, if the court determines that he's not competent to proceed to adjudication, then his case remains stayed. You can discuss with him whether you want to petition for a writ to have this court's decision reviewed by a higher tribunal. But then the case goes forward unless stayed as to Mr. Handte. That's the way I'm looking at it. Any further thoughts? I'll hear again from Mr. Stege.
I have no further thoughts related to that. Something I did just want to back up and touch upon. You mentioned this court has a desire to see a written bail motion potentially.
Well, something that outlines exactly where he would live,
Okay.
with who, make sure that the pretrial services has a current phone number for him, that he understands he would be on house arrest, understands what that means, understands that he would have to, at his own expense, engage in some type of a tracking unit to be on him, to monitor his whereabouts, and play by the rules. Come into the courthouse once a week to meet with Mr. Meredith to check in, something like that.
Okay.
I mean, it doesn't have to be long, but this is our ask, Judge, and here's why you should do it. I'm already leaning that way. And if you followed it by Wednesday, so that Mr. Stege could see it, he could either respond in writing on short notice or be prepared to argue it Thursday morning. I'm in trial next week and then off the following week, so I want to bottom this out with Mr. Hillegas' custody status by this Thursday morning.
So procedurally, Your Honor, I would just ask the court, since right now my office is appointed, as saying my counsel is competency issue, and then it was expanded to respond to the motion from the state related to jail communications. I think procedurally just to expand our appointment to
Well,
to
it's
discuss.
so expanded, so it now involves this as well.
Thank you.
But I'm not, I'm cognizant of you have other matters. This is probably something you may or may not have anticipated. It's short notice, but because I don't have an evaluation or even a date certain, my plan is to amend the order to direct an in-person and to set this for hearing 9 o'clock Thursday for a review of Mr. Hillegas's pretrial release conditions. But if you file something that outlines what you're proposing, if it looks like what the court just identified, and subject to concerns expressed by the state on why they believe that's an especially bad idea, and no guarantees, right? Thursday morning, the court might say, you know what, I've reflected on it further, I've heard from all parties, I'm not convinced this is going to make sure Mr. Hillegas is present for his evaluation, and all it does is set him up for another trip to the Midwest. I don't want that. I want to get him out of there so he can regain his strength and move forward with this case. But yes, order that the standby counsel's scope of responsibility extends to pretrial service issues. Before I hear from Mr. Stege, Mr. Silverberg, is there a position you'd like to advance on behalf of Mr. Handte?
Nothing related to the competency or the bail motion proposed hearing for Thursday, other than would our appearance be excused for any bail motion relating to Mr. Hillegas?
If that's the only thing on the agenda, yes.
Thank you.
You're welcome. All right. And still on the table for today, of course, is the commission meeting comments, and also, though, we're going to argue the other acts, a motion that the state had previously filed, to which Mr. Hante's objected.
Sure.
So let's, and then, so Mr. Stege, any final thoughts before I set a hearing for this Thursday and review Mr. Hillegas' custody status at that time?
Only confusion, because we set this hearing specifically to traverse. I said, be a doctor.
We have to traverse if we had all the evaluations done. We don't have those.
Okay, I would ask the court to make a specific finding of waiver, given that we have 3 evals that the defendant has deliberately failed to participate in. From there, the statute says that the court shall suspend proceedings if doubt as to competency arises.
Yes.
That's the situation we're in now. Yet, the court, so confusion then, if proceedings are suspended, that we're going to a bail situation on Thursday, right? That's shocking to me, given, let's say he is incompetent, and he was incompetent when the court suspended proceedings, that caused him to, or within that context, the defendant fled. If he is incompetent, does not understand the nature of the proceedings, or it's really that last prong, which I'm confident Dr. Lauren will say that's volitional. There's a volitional act, whether he chooses to participate as with counsel or with the proceedings.
And that may carry the day.
And it should.
That may carry the day if I hear from two professionals.
But the idea that we should reward the defendant by, here we are jumping to Thursday, to let the defendant out for his deliberate failure to participate in the proceedings is a difficult pill to swallow for the state.
Well, the court
on the shortened.
Let me say this, the court believes it either has inherent authority, notwithstanding the stay on the substantive matters with respect to this case, or it's ancillary. This is the court trying to find a path forward to make sure that the engagement with the evaluator is as meaningful as it can possibly be. And so if he's home or wherever Mr. Hillegas lives, maybe that inspires him, helps him, strengthens him to do the engagement. But I tell you this: the next time we set this for a hearing, the court will make, absent things out of the court's control, the court will make a determination as to Mr. Hillegas's competency. But the date I'm going to give you is not going to be for another 3 to 4 weeks, because I'm going to enter the order promptly, expanding or clarifying that it's in person, and giving time for that to happen, getting the report and file it and get subpoenas, and we'll set the competency hearing, and I'll make a determination at that time. I'm not going to continue to kick the can down the road. if that's frustrating or that's the appearance, not the court's intention to. I was hopeful today would be that day. I understand the state wants it to be that day, but I'm not finding that there has been a waiver. No, I'm not.
And I do object to hearing, without pleadings, the question of a bail on Thursday. That's,
Well, if
it's wholly unrelated.
okay, how much time do you need then to respond? I can
Let's
sit
come
there.
back in 3 to 4 weeks, because here's what I predict. Should the defendant be released, he will not participate in competency. Throughout his jail calls, he is refusing to participate in competency. Throughout these entire proceedings, he believes the entire process is illegitimate. Yeah, I think it is, hope would be misplaced to think that Mr. Hillegas.
So are you arguing that he's not competent because aid and assist with a reasonable degree of rational understanding?
No, I'm saying he is 100%, he is competent. He's competent because he has a long history of self-represented litigation. He's a kind of an expert in per litigation. As to the third prong, his disparate, to borrow the court's views, his disparate views on the way the legal system works are not irrational. The hallmark of legal incompetency, 95% or more of people who are legally incompetent suffer from mental illness. It is a product of delusional thinking. Most often comes from schizophrenia and related disorders. This defendant has no history of that, right? And so, as an example, and it's recognized within the field of forensic psychiatry and psychology, this idea of widely held but sort of fringe beliefs do not lead to incompetency. For example, we have related to the January 6th election, right? Those people hold widely held, non-delusional, but sort of fringe beliefs. They would be, if this was a case about that, 100% competent. But I don't, the overall picture I want to paint for the court for today is, if he's delaying competency and refusing to meet with multiple evaluators, a reward ought not to be he gets out of custody if as a product of that, right? If there's a medical issue, the first thing I'm going to ask this court for is a subpoena for medical records, because within this milieu of competency, malingering is a huge issue. This idea of secondary gain, actions for secondary gain, such as deliberate use of wheelchairs, right? That is, we saw that with Mr. Handte already. He was in custody using a wheelchair, out of custody, miraculous recovery. I would want to attack that, and doing it by Thursday would not be, and I understand why the court's attention to this issue, right? But in broad strokes, to sort of spring it or to bring it forth now that it is frustrating that he won't participate with NAFCAR evaluators. It is frustrating that the public defender can't get someone to evaluate that person, but it ought not to punish, it ought not to go to the question of bail, it ought to go to, let's efficiently solve this issue of competency.
In other cases, in other departments, some charges are being dropped against people because of delay of being evaluated, and then if a determination of incompetent by the court that's not objected to, then to go to the treatment facility. Some say that delay is violating their constitutional due process rights or some statutory rights, and the effect of that is cases are being dismissed.
Yeah, this is true. Wrongly, I would argue, and our Nevada Supreme Court is going to weigh in on that exact question the first week of June, because
we all need clarity.
Well, and the legal basis for that is there is no legal precedent in a criminal case to dismiss a case on, the Supreme Court has been not worried, the United States Supreme Court, on due process grounds. There's a case that's 300 days. and the United States Supreme Court not concerned about that. This idea that within due process, I mean, like speedy trial, flexibility, sort of weighed in there and sort of weighing of interests. So we are hopeful for clarity, and we suspect it'll be in our direction. In any event, in this case, as sort of reward for deliberate delay, I'm uncomfortable having a bail hearing this Thursday.
Well, if Mr. Prasad by Wednesday files a short motion with an outline of what the conditions would be, how much time would the state need? And then I can set it possibly Tuesday of next week. And
Well,
I can start the jury trial a little later that morning.
I'm unconcerned about what the conditions would be. I'm most interested in this question of the threats made from in custody, the time, the reason for the flight, the long period that he stayed in flight in sort of fugitive status, and an explanation of him being the driver when Mr. Handte was arrested on his bench warrant all around the same time this flight. So,
Well, Mr. Handte knows that he's had no direct contact or indirect contact with Mr. Hillegas while Mr. Hillegas remains on the
Right.
competency proceeding status, and the same would be in Mr. Hillegas' direction for his custody status to change.
yeah. So if the court's asking me what I think
Well, that's a
the court should
preview,
do,
that's a
yeah.
preview of the concerns, right?
Yeah, so if I had my druthers today, Your Honor, I would say set a status in 3 weeks on this would be the fourth person to try to evaluate the defendant. And from there, we can address the question of bail because, I'll point this out in any pleadings I do, which is, it's meant to be an evidentiary hearing, and coming forth and sort of aspirationally saying whatever sort of he'll live, where he'll live, I think is of slight value in that analysis.
Thank you.
Your Honor?
Yes,
May I say something just very briefly?
go ahead.
Because I know it gets Mr. Handte upset, and I think the state does too. We are having a hearing on something that has absolutely nothing to do with Mr. Handte, and the state still takes opportunities to jab at him, and then wonders in amazement when Mr. Handte reacts. So what I would request is that the state be admonished, and there's no need for attacks on Mr. Handte and his use of a wheelchair and things that aren't even relevant to this proceeding, other than to get under Mr. Hante's skin. And that's the record I want to make.
Noted. I don't believe the state has crossed the line, but I'll be more in tune to it on a go-forward basis.
Thank you, Your Honor.
You're welcome. Here's the order of the court then. Over the objection of the state, I'm going to have a hearing. It won't be this Thursday, that's too rushed. Tuesday of next week, a week from tomorrow. Singular issue, Mr. Hillegas' custody status. Mr. Prasad, please, by close of business this Wednesday, file a motion to change status with whatever information you believe would be informative to the court. Mr. Stege, at least one business day before the hearing, please file the state's response in writing. If any, you don't have to file a written response, you can merely argue, but if you want to put it in writing, please make sure I have at least a day before.
If I tender to the court a subpoena for the court's signature for medical records related to Mr. Hillegas for this limited purpose of bail,
I'm not likely to grant that request.
will the court sign a similar subpoena for this on the subject of competency for medical records as they relate to competency?
That decision I'll have to think about later because the competency hearing is going to be set. I'll give a date now and I'll see what the next evaluation looks like. Then you can re-ask.
We do have Tuesday morning, the 8:30 on Ham Jordan.
What is that?
That's the motion for joinder, followed by the motion for probation revocation. That's it for me.
Okay, so 9 o'clock, please, on Tuesday. 9 o'clock next Tuesday, Mr. Hillegas, custody status hearing only. Now, I want to, go ahead.
So, and our appearances wait for that.
It is.
Thank you, Your Honor.
You're welcome. Now, I'm going to give a new date for a hearing for a competency hearing. The court fully intends to make a decision on whether Mr. Hillegas is deemed incompetent to proceed to adjudication, or is deemed competent. But not telling people how to do their jobs, but you need to be aware of what those two branches of the tree look like and what next steps would be. Because if the court finds Mr. Hillegas incompetent to proceed to adjudication, that's one direction, and if the court finds him competent to proceed to adjudication, then the question is, are we still go launch with both defendants for the August trial date? And of course, if he's deemed not competent, then whether there's going to be appellate review. And what happens to Mr. Hante's part of the trial in August. So give some thought to what that might look like. The court will as well try to be as familiar as it can with what the jurisprudence is in such circumstances. I will enter the order shortly that the interview of Mr. Hillegas shall be in person. Whether he's at the Washoe County Jail still or whether he's released somewhere else. The court is not available until the week of June what, please, Ms.
June 12th. You have a trial set that week.
Give me just a moment.
The 8th might be an option. You said you would handle crimson, but you're really crimson that day.
How does Monday, June 12th look for counsel?
You're gonna have a trial starting that day. I'll know this week whether it's actually gonna go. Of course, if it's just related to competency, again, I would ask that our attorneys be with.
Well, that's what it would be for.
I don't see any need for us for Mr. Handte to be present at that hearing, and that way it can go forward timely without my
Okay,
trial calendar.
thank you. Mr. Stege, how's your availability?
It's fine. On that subject though, should the defendant be found incompetent, we might want to hear from from Hante's counsel as to this question of the trial date, but I think we can, if that arises, we can quickly or timely schedule a hearing with Mr. Silverberg to address that.
Okay, so the 12th would work for the state.
Yes, thank you.
And how about Mr. Prasad?
I'm available until.
9 o'clock then on Monday, the 12th of June, and that will be the competency hearing for Mr. Hillegas. Mr. Prasad, if there's any way for you to emphasize to your client, even though he has concerns with the entire process and the legal authority and all the other issues he's expressed and apparently continues to harbor, that if for some reason he's offered an opportunity at an evaluation between now and the 12th, the court's expecting him to engage to the best of his ability. All right, let's hit the pause button there. I want to slide over to Mr. Hante's case. There's a petition for writ of mandamus, I believe, that the court continues to have under submission, continues to look at, the court does not have a decision yet, is working on it, and that should be out in the very near future. With respect to Mr. Hante's recent engagement on April 25th at the Washoe County Commission hearing, and we're all aware, or probably aware, that the public comment piece is now at the end of the calendar, as opposed to at the beginning, which I know has upset several people, but nevertheless, that was the decision of the new chairperson. It was brought to my attention some of the remarks Mr. Handte made at the hearing, including his frustrations with the district attorney's office, the Washoe County Sheriff, the Reno Police, and then he named 4 district court judges, Freeman, Riggs, Walker, and this court. His tone was threatening and unprofessional. Let me give you a couple examples of the phrases he used in an extremely upset manner. Quoting, when the bell gets rung, all of you are going to be put on notice. He also used the phrase, if it's the last thing I do, I will stop it, guaranteed, in referring to the injustice that he believes he and his co-defendant, Mr. Hillegas, are experiencing as part of this case. First Amendment right to express your views doesn't come without certain limitations. Can't be threatening. Can't be made in a way that puts people in fear, reasonable fear of their safety. I know Mr. Handte is frustrated. I know he is unhappy with many things, many agencies, many pieces of government, and of course the way different courts in this building have treated him. But this is unacceptable. This is unacceptable. The people are trying to do their job at the Washoe County Commission. If you have a problem with the way the case is being handled, you go through your attorney, he makes argument and legal briefs to the court. You lash out like this, you name judges, you say, if it's the last thing I do, I will stop it, guaranteed. If you say once the bell gets rung, all of you are going to be put on notice, not cool. Not cool. And I already have in place restrictions on what you can do and talk about the pending case. Did you say the case name? No. Did you identify yourself and Mr. Hillegas as co-defendants? Yes.
Judge,
I mean, you did 3.5 weekends recently for being in contempt for the interview you gave on the blog, on the radio, and you know I tried to find a balance. Mr. Stege asked me at that time, as I recall, to put you in jail for 30 days, I think, as a sanction, and the court went significantly under that. Now, does that mean it was a picnic for you to check in every Saturday morning till Sunday night? Of course not. Disruptive, embarrassing, upsetting, I get it. But the frustrations and the angst you feel, you have to find lawful, respectful ways to release them, particularly when you're in a pending case and especially when there's a partial gag order here. So this, Mr. Handte, you're acting like your own worst enemy. So those are my preliminary thoughts here. Let me hear from the state, please, on what they would have the court do, if anything. Then I'll hear from Mr. Silverberg, and then if you'd like me to hear directly from your client, Mr. Silverberg, on this issue, I will. When we're done with this piece, we're going to move to the state's motion for other act definitions. Okay, Mr. Stege, your thoughts.
I would like to have marked an email from Mr. Handte to, among others, staff of the Sheriff's Department, the aforementioned people on the County Commission, representatives on the County Commission, as well as to Mr. Silverberg. I'll quote from it, and that it was forwarded to me.
What's the date, please?
April 26th, 2023, 11:38 a.m.
All right, so the next morning after the commission meeting, right?
Yes. Various grievances, U.S. Attorney, Governor Quinn, Brian Sandoval, but reflecting on this court's concern, sort of the threatening nature of it, and I quote, "I'm not playing any more games with the corruption in this useless county and state. I've lost everything and have nothing left to lose but my life. And after being a law enforcement officer for 30 years, I was never afraid to lose said life in the performance of my duties. And I'm not afraid to do so now, nor am I afraid of any of you folks in the legal profession here that are on a personal vendetta that, all caps, will be exposed one way or another, ... Trust me, or don't on that aspect." I'd like to have this get an exhibit.
You may approach the court clerk. Mr. Silverberg, have you seen the email?
Yes, Your Honor.
All right.
And so I reflect on the court's concerns about threats, sort of how we got here. Unusual to have a gag order, very unusual. The hearing we had recently related to the question of violations, the contempt order. I reflect on two things. One, right, the court was rather restrained in its, right, as the court mentioned, restrained in its approach to the contempt. I don't know what else to do. I mean, the entire basis of this was related to contact with witnesses, this idea of trying the case in the media. It is, I mean, this is a different case for the people who involved in it because you have a former law enforcement officer saying he's not afraid to lose his life. That is, and and it's now, right, it's moved on to the commissioners, staff in the sheriff's office. I reflect also that sort of the second issue is I had suggested in my, I think, the original bail motion that we heard, this question of a mental health evaluation as a condition. Now, I don't need to know anything, so if the court were to follow my reasoning on that, I would suggest the court maybe order a mental health evaluation and that he comply with any, as a condition of probation, he comply with any recommendations. This sort of mercurial sort of up and down is, I think, potentially a cause for concern for the court. This idea that we have orders directing or prohibiting certain conduct, and that is, we keep coming back to it. So on that, overall, I would underscore or highlight the state shares the court's concerns about sort of the tone of the public comment as well as emails.
Okay, give me just a moment. I'm going to hear from Mr. Silverberg. I just want to read the email again. All right, I'll have this Exhibit 1 introduced as the purposes of this hearing. Admitted for purposes of this hearing. You know, if the email had left out the part about I'm not afraid to lose my life now. You know, I wasn't afraid as a peace officer for 30 years, and I'm not afraid now. If that part weren't in there, it would be less indirectly concerning to the court because it implies that Mr. Handte is in a frame of mind where, you know, he's willing to do whatever it takes. I mean, that's just the undercurrent. What do you think, Mr. Silverberg?
Well, Your Honor, I don't think we can look at this in isolation. Of course, we have a history with Mr. Handte, who speaks a certain way, very frankly, but his actions show that he's not intending anything violent. I guess.
Well, let me stop you there. Did you see the video? I mean, his body language, his aggressiveness, his tone suggested that he was one small spark away from snapping. Now, maybe his motor runs in 2 speeds, fast and faster, and this is the way he lives his life. On the other hand, I'm trying to remember the last time somebody went to the Washington County Commission and identified judges that they had angst against, and with that type of tone, cadence, and using things like, if it's the last thing I do, I will stop it, guaranteed. And when the bell gets rung, I mean, what does that mean to you?
To me, what it means, again, in the entire context of the way Mr. Handte has proceeded in this case, is that he wants to expose what he believes are injustices in the system. And if it's the last thing he does, even if it relates to his freedom, because that's the way I read it, he's not afraid of the consequences that come by him exposing what he sees as corruption.
With the trial upcoming in 4 months, when there's already a partial gag order saying what he can say to whom about what?
Certainly,
And then he goes
but I
and
don't-
identifies himself and his co-defendant and the judges that have had some piece to be involved in this? Isn't that a
Understand.
violation of his pretrial release? Shouldn't I revoke his pretrial release right now and set it for a Johnston hearing in a couple of weeks to see what we can do to get him back on track?
I don't believe so, and here's why, Your Honor. What he's saying, again, I believe is strictly related to his passion about the case. He did not speak about any of the underlying facts of the case in this one. That's what got him in trouble last time, is he went on and actually spoke about the guardianship and the abuses and all that. No, that's not present here. It's a general expression of frustration and his belief in a system that is not treating him fairly. And does he have a way of saying it that could be alarming? I understand that. But, Your Honor, his actions show completely the opposite. He's done nothing but filing legal documents. He tries to file things on his own. And he wants the system to work for him. I don't believe that there's an expression of violence.
Expression, how about undercurrent? How about veiled? How about camouflaged?
So I think if you were to look at it in isolation, one might feel that way. But knowing how Mr. Handte has appeared before this court, always timely, always professional, and other than his mouth getting him in trouble, he hasn't done anything else, Your Honor. He hasn't. So is his tone of speech alarming? I understand that. I'm not as concerned because I've been here from the beginning, well, almost the beginning, with Mr. Handte. So I've seen how he is. I know he's passionate, but I haven't seen him take any action or be even close to taking any action against anybody in an inappropriate manner other than verbally lashing out. And I think he has done so. It's not my preference that he go speak this way. It's not, but I also have to understand that he has a right to speak. And he has a right to voice his frustration with the courts, with the prosecutor, with me. He's got that right. In this particular case, Your Honor, he did not, I don't believe he crossed the line of the court's gag order.
Either by the email or by what he said at the April 25th Board of County Commission meeting?
Right, because I don't believe he went into any of the facts of the case. It was more general expression of, hey, you know that you're certain people in this community, you know you're corrupt, and I'm going to expose it. And I think that's supported by the fact of his continued attempts to file pleadings before the court, to use the judicial system and its procedures to vindicate his rights. And he's done nothing of it.
Thank you. Mr. Stege, final thoughts? Well, hold on a second. I said before, I'll give Mr. Handte an opportunity to speak if his attorney thinks it's a good idea. Mr. Silverberg.
Against my advice, Mr. Handte wants to make a brief statement.
Okay, just as to this issue, now,
Thank you, Judge. First and foremost, when I put the uniform on for 30 years, I wasn't afraid to lose my life. If I was, I would never put it on to begin with. That is just a statement. Doesn't mean I'm going to go out there and do a Christopher Dorner thing. I'm just saying, I've got to the point of frustration. You don't know this, the court doesn't know this, but there are entities out there that are surveilling me, tracking me based on what's around my ankle, and have been observed by other people other than myself. So I do have a little bit of concern about that. I don't know who's doing it. I'd like to find out. I believe this gentleman here might know. But I did not speak on the merits of the case, nor will I speak on the merits of the case. It's not your order, Judge. I followed your order. No job in this world that I know of, the 63 years I've lived my life, is free of criticism. But as a cop for 30 years, I got criticized a lot, but I had to take it. And that's just part of life. So if people don't like the criticism, I mean, it's just like I just said, it's part of life. I am frustrated, and I'm upset about, the co-defendant here and myself having been brought into this situation. It bears mentioning to you, Judge, that my life has been turned upside down. I don't think that's fair. I don't think what the state has done against myself, Mr.
well, now we're moving more towards.
But
You're putting into context what you said to the commission, and you're putting into
I did
context
not
that
threaten
email.
anybody with violence. nor would I threaten anybody with violence, that's.
But you need to choose your words differently, because your view of, I'm not threatening anybody, and the recipient's views might be different. You gotta know your audience too. When you use phrases like the ones the court has identified here, you know, to a lot of people, this court included, it seems to be you're right on the edge, if not got 1 foot over. And you wanna stay away from that. You're a defendant in a pending criminal justice case. You're on pretrial release now, even though you've done things that directed this court to put you in jail from time to time. I don't want to put you in jail again. I don't want you to. You don't want to be put, but you're sort of digging yourself in, and you really need to knock it off. Find ways to, if you want to get your views out there, it shouldn't be directed at any person that's involved in this case. It shouldn't be in any way a threat to potential jurors, that if they ultimately decide this case in a way you don't like, that they have to be concerned.
And Judge, I've never tried the case in the media. They have, not me. The media does not want to talk to myself or Mr. Hillegas, so therefore it's a one-sided interpretation. I've never tried the case in the media. I'm just frustrated and angry. You're right. I run fast and faster. I did that for 30 years. I don't think I can ratchet that down. It's just been part of my life for 30 years. So if my faster is a little bit of concern to you, I'll ratchet it down. And
Please.
And that's my statement to you, Judge, and I promise I'll be good on that statement. Thank you.
Thank you. Any final thoughts, Mr. Stege?
The pattern here is it's patent, right? From the inception, when we, in justice court, when we're talking about bail, it's pushing the line every time, you know. If, God forbid, violence happens, this is what we're going to point back to. I have no shock at all. I mean, he said it's not threatening. I mean, that's ludicrous. It's ludicrous to say, I'm willing to lose my life over this. Right? I have nothing left but my life as not being threatening. I mean, it's transparent. And the idea, that people act appropriately in court is of almost no value. Right? Because, I mean, it's the easiest thing to do, is the lowest standard of performance, right? So, the court doesn't take action. Every time the court takes action, it works for a little bit, then it comes back. So, there's really nothing else to say. The court should take action.
Bottom line. The court is not finding you, Mr. Handte, in violation of your pretrial release. I'm not revoking that. However, I'm going to give more thought to whether, and I'm allowed by statute, to modify the terms of your pretrial release, to add something, to require something, to limit something that I haven't yet thought of. So an order will issue if the court intends, based on this hearing, to further subscribe what you're allowed to do and what you're not allowed to do. But as of this moment, I'm not remanding you to the custody of the sheriff. So I strongly encourage you to use better judgment, despite your frustrations. The state has a motion to admit other act evidence with respect to Mr. Handte. Now, just so I'm understanding what is being asked by this motion, does the state want, if it succeeds, to have an opportunity to discuss this in its opening statement, to introduce such evidence in its case in chief, to call witnesses, to further these issues, or only bring it up in the event Mr. Handte takes the stand and were to deny sophistication in the civil justice or administrative justice arena, or to deny that he has been involved as a peace officer in the criminal justice system? What exactly is the ask, and then tell me why I should do it.
So the ask is, so under bad act analysis or other act jurisprudence, if it's admitted, it would very often be admitted or mentioned in opening statements, right?
So admitted for all purposes.
Admitted, right, for Big Pond says for any relevant purpose. Now, as a matter of trial strategy, it's often the court probably sees where the other act that is admitted is rarely mentioned during opening statement, and it really sort of follows the flow of the evidence. So because the state currently intends to introduce the defendant's statement, right, that is our right to introduce the defendant's statement, sort of in which I like the court's words, sort of denies sophistication in sort of the civil realm. This makes his history of litigation in the civil context relevant, right? Relevant, really this question of its knowledge, right? Any claim of being duped, right, is belied by the fact of.
That he knew or should have known.
Yeah, knew or should have known, and given, above average, I would say, for a citizen's involvement in civil litigation, quite a number of cases involving civil litigation. And more precisely, the case that involved garnishment, right, because that is this question of whether law enforcement enforces civil judgments, right? As a general principle, that does not happen. So, in this case, we have Mr. Handte suggesting to or asking, police department to do something about this civil case, about this civil judgment. A thing he knows based on experience as a law enforcement officer, including having been the sheriff of the county, and his civil litigation experience, that does not happen, right? And in the narrow context that it does happen, the case he was involved in, the CB03 case, is you have an order that is directed from a district court judge to the sheriff of the county to say, enforce this order, garnishment being for one of those limited purposes. So should the court follow or grant the motion, I foresee, given the history, it's very likely that we'll see Mr. Handte testify to sort of the years of law enforcement experience, but let's say he does not. I think that is still quite relevant, and really, and I would say that's gross in a gross context, meaning that the anticipated testimony would be rather brief, saying Mr. Handte here's his history in law enforcement, working as a state trooper, working as a deputy sheriff, and working as a sheriff of a county, et cetera, including this aspect of while the sheriff of Mineral County, right, the special duties that come along with being a sheriff are the very limited context in which the sheriff enforces civil orders, but also that the sheriff, as party to lawsuits and in those narrow contexts where the sheriff does enforce orders, has seen what bogus pleadings look like and what real pleadings look like. That's the overall tenor. So a portion of the motion, ladies and gentlemen of the jury, he was a law enforcement officer. He knows or should have known what legitimate legal pleadings are like. This on its face is obviously bogus, therefore he ought not to have relied on it, right? His reliance on it is false, right? Or his statement that he relied on it is false. The second portion of it is his own individual participation in civil litigation. Again, I imagine this would be a broad strokes, the evidence would be broad strokes. He's been involved as a party to, I think it's 8, the number of civil cases, and for purposes of this trial, I think the only one that would be relevant for the jury to hear about, I think it would be fair to say, he's been involved in 8 lawsuits, and I don't remember the exact number, let's say it's 8. He's been involved in 8 lawsuits as a litigant, and during that process, as a litigant, you see and are served with pleadings, which that would tell you what a true pleading looks like, as opposed to the bogus ones here. Second, so that's about as facial as it would get, and then the deep dive or the most detail that the jury would hear would be on the garnishment case, because it is so closely analogous and so goes to the heart of Hante's intent. And Big Pond says it's not limited to the minute rule, but in broad strokes, I would say it's this question of intent and really lack of mistake, this idea of feeling duped, or this statement of suggestion that he was duped by it undermines all of it and speaks to the true intent, which is to do it despite there being a real order, in the GR case, or GR out of Judge Walker, right? His intent to do it against a true, legitimate order on the subject.
Thank you. Mr. Silverberg.
Thank you, Your Honor. As outlined in my opposition, I think the first big problem, I think, with the state's motion is being a law enforcement officer, being involved in civil litigation, are not prior bad acts. It's not something that, at least in this courtroom, we don't see that as a bad thing. So I think that's the first big problem.
Well, let me ask you this, if I agree with that, then do I deem this denied because it's not what it purports to be motion, or do I say, well, it's a motion in limine for sort of an advanced ruling before trial on evidence the state otherwise would seek to introduce?
Well,
Can we go that route?
I think since the state labeled its own motion as a prior bad act motion, it's appropriate to deny it on that basis. If the state wants some advanced ruling on any of these other matters, then I would want an opportunity to respond in writing to that. I think it is, as Your Honor knows, as do I, because we've been involved in the civil world too. Civil litigation is extremely broad, extremely broad. And this brings up an issue that arises allegedly in the context of guardianship and orders. Nowhere in the state's motion is there anything showing that Mr. Handte has some special knowledge in guardianships. If that were the case, might be a little bit tougher of a sell, but or tougher of an argument on my part, Your Honor, that it's not relevant. But dealing with garnishments has absolutely nothing to do with this. Nothing whatsoever. It's not a prior bad act. It's not relevant. If Mr. Handte decides to take the stand and say, I've never seen a legal document before, well, then he's certainly opened the door for the state to cross-examine him. But as this stands as a motion for prior bad act, admission of prior bad act evidence, there is no prior bad act here, and it's completely irrelevant. And it's also extremely prejudicial because the state is trying to paint Mr. Handte as some litigious person who should know better. And it's just not, it's not part of this case. It's not relevant. It's a huge stretch. So I would ask the court to deny this motion. And if the state wants an advanced ruling on the relevance of some of the other things that he's brought up that are not bad acts, but may be relevant depending on the testimony, then I think the state should make that motion, and I would file my opposition accordingly.
Okay, thank you. Mr. Stege, briefly respond, please.
I don't understand that argument. The statute says other crimes, wrongs, or acts, right, that may have some character, sort of tone to them, can be admissible for
So no crime, right?
Yeah, right, like, I don't have to allege the idea that
Hold on. So crimes, wrongs, or acts. So these aren't crimes.
No,
They're not wrongs.
no,
They're other acts.
there are other
That
acts.
may be informative to the jury on the truth or lack thereof of any fact at issue in this case, right?
Yes,
The court has to, before the court were to allow some or all of what you're requesting in, the court follows the jurisprudence, the statute, finds that these acts occurred clearly and convincingly, finds that they're relevant to the inquiry, and finds that their probative value is not substantially outweighed by the danger of unfair prejudice, right?
yes,
Now, you heard, among other things, first the defense says, Judge, don't let this in because, you know, we say, you know, bad acts as in usually substitute for criminal act. but the statute doesn't exactly require that. So I understand your argument. But the look of 8 possibly civil actions, it makes it look not just litigious, but it makes it look like Mr. Hante's flawed, who gets sued or sues 8 times. That must be an imperfect human, somebody that can't find his or her way in the world, and they have to resort to the court. So that paints him out to be a bad guy. And then on the question of, as I understand the defense argument, his familiarity with legal process because of his peace officer background, that doesn't equate to he necessarily understood what guardianship type of official pleadings look like. Are you saying that goes to the weight but not the admissibility or something?
Yeah, I think that is one, right, that's a narrow interpretation of that. Now, of course, the court sees how that's dividing and conquering, right? Like, you can't have it be the case that you are a party to a civil case, a bunch of civil cases, right? But there's too many of them, and therefore, but as a law enforcement officer, you're not really involved with civil cases, therefore, he's losing on both, right? That, you can't have it be both ways. But to drill down a little bit, the CD03 case is the survivor's trust, it's a guardianship trustee case, right? It is so on point that it must be admitted. And the overall idea that, well, because the styling, it was styled wrong, right? These aren't really other crimes, therefore the court shouldn't even consider it. That doesn't really pass muster. The question is, how big is the character inference, right? The balancing is, how strong is the negative character inference that flows from having been involved in prior civil suits? I suggest it's not as strong as the court would suggest, right? Civil suits are rather common, right? What is the negative inference from being involved in civil suits? You're either wronged by somebody, and I don't even see that we would go that far, right? Whether he was the person wronged or sort of the injuring party in this case, I think it's not that strong. And even if that is the case, this is how bad acts analysis works in the jurisprudence on it, which is that character, whatever character inference, is that fairly prejudicial, right? And is it outweighed by its fairly relevant purpose? And the fairly relevant purpose here is, as stated, right? This idea that he tried to use his law enforcement experience to boost or endorse this bogus legal document as a basis to the feeling that he was duped into going there on a bogus legal document. That is entirely fairly prejudicial. Fair prejudice comes from the relevance that, wait a minute, you say you're duped, but here there's strong evidence that you have been involved in litigation and you've seen what real, legitimate legal pleadings look like, including in a trust case, a case loosely in the same area of civil law. Now, yes, that's broad. That civil law is broad. That's a nice defense argument, but it doesn't preclude its admission, right? That's sort of narrow interpretation of it. The broad interpretation is you weren't duped, you knew it was illegitimate, and you therefore acted with the intent that the state describes. This burglary, going in knowing, with intent to commit a felony, knowing that you had no legal grounds to do so, that the grounds for doing so were emotional, not legal. And so now, so I think that is fairly, the court should be on that basis. Now the court could take a step back and say, well, maybe it's not really bad act or other act evidence. Maybe it's just a question of prejudice versus probative value, right? Because there isn't a strong character inference that flows from having been involved in civil litigation. Unless we went
So that depends. If
Depending on
they're 8, right? If they're 8 and I let you go to each one.
Yeah.
That's different than if I say, I'll allow the state to ask the question of whether Mr. Hante's been involved in several prior pieces of civil litigation. That
Yes.
may be a way the court
Yes.
cuts that cookie.
Yeah, because that can happen in a variety of contexts, and although the scope of civil law is broad, he was represented in all of those instances. Fair inference that he himself saw the documents, and even, in his capacity, although none of them really are in his capacity as a law enforcement officer, but one envisions a jury who doesn't know any better. If you're a law enforcement officer, you might be a type of person who gets, served with lawsuits. More civil lawsuits might tend to flow from that line of work. So if the court just sees it as a prejudice versus probative, I like that analysis even better, because then the court's saying there's no real negative character inference flowing from having been involved in civil litigation. I think that's.
Well, I haven't made my mind up, of course, I have to
Right.
think about it in light of these arguments, but I'm saying that might be.
Yeah,
a bridge.
the court might say that's too many, but the court ought to allow the state with the most precision and the most detail to go into this trust case, because it is.
I understand, you think that's the one that's as four-cornered, consistent with this case as any of them.
Yes, and to the extent that there are, the allegation is that, in that case, that Handte and Dozen sort of misused the trust. So I think there is room, and appropriate room, for the court to sort of sanitize, what's the word I'll use, right? Omit portions of that are too, that the character inference is too strong.
Understood.
I'm not here to throw dirt on him for having been involved in that. I would be here to say he's been involved in a case very analogous, right? Same area of law. In that case, a trust case, the sheriff, there's an order from the sheriff. He was served with that order. He knows what it looks like. Therefore, when he did this, it goes to show his truth.
I got it. Even though it's the state's motion and burden, Mr. Silverberg, if there's something that, based on this dialogue I just had with Mr. Stege, you'd like to respond to, tell me. If not, though, I'm going to have this matter submitted.
Yeah, Your Honor, I would just be repetitive. I think our opposition, what I've said already, addresses those issues, and I don't think it's an appropriate motion to grant.
Thank you. All right, the matter's under submission. So here's where we are. We're going to conclude this hearing in just a moment. I'm going to see everyone back next week. I'm going to see Mr. Hillegas and his standby counsel next week. The state brief to be followed by this Wednesday. State can respond at least a business day before. Make sure copies are emailed to chambers and to defense counsel. I'll make a decision on Mr. Hillegas' custody status. An order will issue directing that his next evaluation be in person. We have our June 12th, I believe, hearing on competency, which the court fully intends to make a decision one way or the other. So if the parties want the court to hear from witnesses, make sure they're subpoenaed and ready to go. Mr. Hante's been reminded of the court's concerns on his email, and also more directly comments he made, and the tenor of the way he made them in front of the Board of County Commission, and the court reserved its right to impose additional term or condition of his pretrial release. I'm still thinking about that. And then under submission is the motion for admission of other acts evidence that state just argued. Thank you, everyone. I wish you a nice afternoon. The court's in recess.
Thank you, Your Honor.
All rise.